My name is Rachel McDonnell. I'm a Principal Associate in the Commercial Disputes team at Mills and Reeve, and I'm joined today by Alex Russell, a partner in our employment team, who's going to be giving an immigration update. Thank you very much for joining.
Great, thanks very much, Rachel. Good morning, everyone. Really good to be with you. Lots to cover this morning. Immigration, as always, remains a really sort of fluid and dynamic area of compliance. So I'll try to pick up stuff that's going to be useful practically for your role as in-house lawyers, and also do a little bit of sort of policy gazing into the future, see what might be on the horizon for 2023, given we're in such a sort of interesting time politically and economically at the moment. So I thought we'd spend a bit of time looking at right to work changes. There have been some changes over the past year or so, some bits and pieces that you might well have been working through as in-house advisors. I know quite often I get queries from in-house lawyers saying, listen, to check something on this, I'm getting queries internally. So we'll look at some of the changes in that area, do a little bit of a roundup on some other areas, focus on a couple of issues where in particular recently I've had a few queries and been giving some advice in, and as I say, look forward to what's on the horizon for 2023. So plenty to be going on with. As I say, do stick, as Rachel said, do stick questions in the Q&A, and we'll see if we can pick some of those up at the end after I've talked through some things for about 30 minutes or so. Great, so right to work updates. Let's look at these issues first. Interestingly, my colleague, as I was preparing this morning, Tracy Yates in our immigration team, who is always hot on the stuff off the press, said that there's been an update to the right to work guidance published today, the 1st of March, this morning. So I had a very quick scan before I came on. I don't think the content has radically changed in any areas. There's a few more details around identity service providers that I'll touch on in a moment, and a bit more detail around right to work issues when you're checking those for students who are doing some work. But updated guidance today, so do go on the gov.uk website to pull that off if you want to have a read through that. It does highlight at the beginning the areas where there have been changes in the guidance compared with the last version. Just really by way of recap, some of these are changes that have happened a few months ago, but I think it's worth going over them because I think lots of people are still working through the issues that come out of that. Just a reminder that from the 6th of April last year, there was a really big change in how employers have to conduct right to work checks. And now you can only do online checks for people who've got biometric residence permits, cards, or indeed other types of e-visas. What essentially that means is that the old system that we used to have of people being able to present to you the hard copy biometric card that you could check has gone out of the window. You have to do online checks for all of those people if the check is conducted on or after the 6th of April. Obviously, that will be new joiners in your businesses, institutions, and also those who are extending their visas, getting a new visa, you're doing a fresh right to work check on that. Whilst they're in employment, it's now all on the online system, reflecting the government's approach to digitalising much of how immigration is done. Good news is retrospective checks, they're not required for checks conducted before the 6th of April 2022, so you don't have to go back through and pull people up and get them to bring information in, so you can do online checks, provided you did a valid check on hard copy documents before the 6th of April 2022, that will stand for the duration of employment or until that visa expires and a fresh check is required. Also a reminder, from the 1st of October last year, the system that we had to allow more flexibility for checks because of the remote working, all the COVID pandemic issues, that ended on the 30th of September last year. Again, you don't have to do retrospective checks, but we're now into the normal regime, if you like, of the normal methods of checking documents. So where you do have to do a hard copy check, having the actual physical documents in your hand, for example, a passport, when you conduct that check. So just really by way of reminder, where does that leave us in terms of the system at the moment? You've got these sort of options, if you like, for conducting checks. You've got the online check, which, as I say, is increasingly the way with people with visas. You'll be doing checks. So that's using the Home Office portal. The person gets a share code, shares that with you. You can go on the system, check that the person's got the right to work. It pulls up their photo, details of their visa status. Share code is now valid for 90 days. Do make sure that you use the employer section of that checking service, not the landlord section. Otherwise, the check that you conduct won't be valid. There are sometimes, in my experience, gaps in the information that's available on the online system. Sometimes a photo isn't there. You just really have to go, I think, with the information that's available on that system. That should be sufficient to give you the statutory defence that you need. Or the second way is the manual check. So that is where you have to physically check the hard copy documents, typically a passport. There are other documents in those two lists in the guidance that you can use in some circumstances. That basically leaves us with this applying where you can't do an online check, or you're not using what's called an identity service provider. So really, it's going to be people who are British and Irish nationals with passports from those countries, or people that have still got stamps, validations in their passports, which you'll be checking in physical form. So you'd have to check the documents physically, have those in your hands, but you could still have the person on a screen whilst you do that check. It's having the physical documents in your hand, not the person in your presence. That's the key issue there for a valid check. That does bring into play identity service providers, which I'll come on to in a minute, and a bit of a rationale for thinking about using those. Or we've got the employer checking service, which is there in limited circumstances. So where somebody's got a pending application and you need to check whether they've got the right to work, you can, of course, fill in that online form, get that lodged within 5 working days. You should get a response back confirming whether or not the person has the right to work in the UK. The identity service providers is the interesting and developing area. This is something that the Home Office has introduced, essentially as a way of being able to conduct online or remote checks, if you like, for British and Irish passport holders. So essentially, you can engage with an external certified provider, pay them fees, sign up to one of their packages, and they will then do various checks behind the scenes and be able to provide you with the information that you need in order to check that person's got the right to work. So kind of outsourcing, if you like, the check to a third-party provider. Basically, it's a mechanism enabling you to do online or remote checks for British and Irish passport holders, which will, of course, be, in most cases, the majority of the people who are starting work with you. There is a published list of certified providers. There's a bit more detail in the 1st of March 2023 guidance published today. The fees do vary depending on the check. I think the key thing to note is that you have to make sure that you engage all of that properly, you engage the service provider properly, they've got the right accreditations, because the responsibility for the check still fundamentally sits with the employer. You can't outsource that liability. So you still have to make sure everything is in order with that provider, and you're giving them the right information, they're giving you back the right information in order for that check to be valid and give you that defence to a civil penalty in the event the person doesn't have the right to work in the UK. I think where it's particularly helpful might be if you've got, quite a huge turnover of staff, or you're engaging a lot of people who are British and Irish nationals. It may be that you feel a need to automate. It's not practical to be doing checks on hard copy documents in the new kind of remote working, agile working age. You can't be asking people to send in their passports to you. They're not keen to do that. If you're in that situation, this is something to look at. Look at the Home Office guidance and follow through on some of those details to see if it's something that might be helpful for you. Certainly worth looking at. If you've got a small number of staff, don't have a huge number of new joiners, it may well be more hassle than it's worth and an extra cost that you don't need to be bearing. I wanted to touch on a roundup of a couple of other issues, moving on from right to work issues, which may be of interest. You're probably familiar that we've got sort of 2 main kind of work visas that are sponsored in the UK. We have the skilled worker visa, which is the main work visa route, and then what we call the global mobility route, which is essentially a route designed to enable businesses to transfer individuals who are employed by group companies linked by common ownership or control overseas to the UK for a period in order to be able to sponsor them for a role in the UK. In general, the global mobility route has held very few advantages compared with the skilled worker route. So it's not something that most businesses have been looking at using. So even where somebody may qualify for a global mobility visa, in practice, most of the time, the skilled worker visa, you can qualify for that and it makes more sense for various reasons to go down that route. There have been some changes in the global mobility route, which may mean there's an additional rationale for using that route where the individuals qualify. And this relates to the fees that are payable. So for most sponsors, for most roles, there are some exceptions, but most of the time you have to pay what's called an immigration skills charge when you sponsor the person for a visa. Certainly in the skilled worker category and historically in global mobility. And that is typically £1,000 per year. So 5-year visa, £5,000 upfront cost on top of your normal employment costs, the costs of the certificate of sponsorship, and if you're reimbursing some of the individual's fee costs, those as well. So a significant extra employment cost. There's an exemption now for sponsors paying the ISC when sponsoring EU nationals under the global mobility route, the senior or specialist worker sub-route of that, which is the route that we're talking about. There are some criteria to note. So they've got to be transferring to the UK from a business established in the EU, obviously in the same sponsor group of companies, and the certificate of sponsorship can't exceed a 3-year period, and you've got to provide details on the certificate of sponsorship. But I think it's worth looking at again, if you've been using skilled worker as a default setting and you've got lots of global mobility issues going on across an international group, it's worth looking at this again, thinking, okay, we could actually be saving a stack of cash here by making use of this route if these circumstances apply. Certainly something I think to revisit if that's your situation. And could this be a little bit of a direction of travel from the government? The interesting thing, as we'll see in a moment, actually, is that the immigration system in many ways is more flexible. It's easier for businesses to get people into the UK than it was pre-Brexit, aside from the loss of EU freedom of movement. And there's sort of more caveats and exceptions being applied across the system. So, could it be that with a need to generate growth, pull some levers around that, immigration's a key one, that these sorts of exemptions may start to extend to the skilled worker route or certain roles in that. So, for example, some of the more highly skilled roles, perhaps those on the shortage occupation list, perhaps roles, in the NHS. It's easy to see how the government may be looking to extend these sorts of exemptions more broadly over the coming months and years, I think. More on that in a moment as we do a bit of crystal ball gazing. The other point I wanted to mention by way of roundup is some practical points around processing times, but it's really worth having on your radar if you are, as a business, engaging people on visas. There's been a lot of fluctuation in processing time for visa applications recently, linked to a number of things, the Ukraine war, the government deploying lots of resources to deal with the applications and schemes that have come out of that. Still kind of, I think, coming out of the COVID pandemic, the shutting of various overseas hubs and so forth. So a bit of a warning that potentially there are still quite long waiting times for visa applications. So for the skilled worker route, the main work visa route, you might still be looking at around sort of 8 weeks in country potentially. Interestingly, we have come across some applications that have been processed much more quickly than that, particularly for individuals who are EU nationals, let's say, using the app, the digital app on their phone to use their passport for checks. But it could still be longer than that, particularly if they're not making use of that app. Entry clearance is not as bad, so applying from overseas, the service standard is 3 weeks. And these have come down from where they were, but there is some flux still. And I would say that if your teams are looking at getting people in quickly, do seriously consider the priority service option, which is a 5 working day turnaround time, to try and make sure that you get people in more quickly or starting with you more quickly, and you're factoring that into your recruitment timelines. Otherwise, you might think, okay, we sponsored the person, they've made their application, but if it's in country, you could be looking at several weeks before they're in a position to start. I've seen a few cases where that's a bit of a shock and creates some problems for the business. So look at the latest processing times and consider very carefully the priority service where there's an urgency in onboarding the person. Wanted to focus on a couple of issues that I think is worth thinking about, which I've had a few questions on recently. So a couple of issues. The first is switching from the graduate route to the skilled worker route. So as many of you will know, there's a graduate route visa. At least at the moment, the government's making soundings about trying to make it more difficult for international students to kind of bring down immigration numbers. Watch this space on that. But at the moment, there's a graduate route which is designed to enable international students to get a visa, enabling them to work for whoever they want, essentially without restrictions, for 2 or 3 years, depending on the level of study that they have done. So it's a great option because international students graduate, they get this visa, you can employ, you don't have to sponsor, you don't have the costs, the hassle, the risks associated with that. But what many people on graduate visas ask for is, well, please, can you switch me over and sponsor me for a skilled worker visa straight away? The reason being that the time spent in the skilled worker route counts towards your 5 years continuity for settlement or indefinite leave to remain in the UK. Time spent in the graduate route does not. So you can see why people who've recently graduated in that route, they want to switch as quickly as possible to get the clock running on their 5 years to get to, if you like, the holy grail of settlement free of immigration control in the UK. Do you have to agree to that request is the obvious question that I'm asked quite often. No, you don't. The person's got the right to work in the UK. You can just employ them on that basis. You're not required to switch them in. It's going to come down to a commercial question on whether or not you need to be willing to do that to attract the people that you need to recruit. Some businesses, I'm aware, particularly in life sciences, technology sectors, where there's lots of demand in a hot labour market, are willing to do that early doors as a way of essentially attracting the person to the business over and above some competitors. So you might need to think about being willing to do that, even though you don't have to, in order to recruit the people that you want to do so. Something to think about there. Second area is redundancy, restructure and sponsored staff. We're obviously in slightly challenging times at the moment. The labour market is very tight, but I know that some businesses, some institutions are having to look at restructuring and making some redundancies, or they will be doing possibly over the months ahead. Just really a bit of a red flag that the way that the immigration law requirements sit with employment law requirements is not always that easy. They don't always dovetail that well. If you've got somebody on a sponsored visa, they are sponsored for a specific role with you in a specific SOC code, and certain requirements have to be met around that. What you can't simply do is somebody move from one role to another role on a sponsored visa. Either change of circumstance reports would need to be made to the Home Office, or if the role is sufficiently different that it falls into what they call a different SOC code, then a fresh visa application, a fresh certificate of sponsorship would need to happen. It's worth thinking about. If I've seen some car crashes over the years where people think, well, we've got all these requirements around redundancy, fair process, slotting people into available roles, and the immigration compliance stuff is missed. You need to have that on your radar, build that into your processes, make sure that timescales are adjusted accordingly, and if necessary, that where somebody is being slotted into a different role, to check the role does qualify for a skilled worker visa, the salary threshold's met, for example, and that if a fresh application is required because it's in a different code, that is made and approved before the person starts in the new role. Otherwise, you could get in a real mess. You could have serious sponsor compliance failures on your part, and the person potentially has been working in the UK in breach of their visa restrictions, which may be catastrophic for them and indeed their family members if they're also here as dependents with them. So just red flag that, make sure HR teams, if they are working through those processes at the moment, have on their radar, do we have anybody on a sponsored visa? How do we have to build those extra requirements into our process in light of that? So in the last 10 minutes or so, I wanted to do a little bit of horizon gazing for what we could be seeing in 2023. As I say, it's a really interesting slash challenging time at the moment. There's obviously something of an economic downturn. I suppose how deep that is and how long that is a bit of a subject for debate, but probably certainly the worst since 2008, arguably more structural. But linked to that, we've got a real skills shortages in the UK economy across many different sectors, particularly high skilled roles, but also low skilled roles or deemed low skilled roles in agriculture, care homes and so forth. And there's a real need, businesses would say, to bring labour into the UK to drive growth and also fill those shortages. I think that Tony Danker, at the CBI annual conference towards the end of last year, was referring to this, talking of the skill shortages, a need for increased economic migration, how that's a barrier to growth if we don't get it, and calling for all sorts of different visa routes in light of that. And I think there are some signs, in light of some of the changes that I've touched on, that the government does recognise that, but it's obviously set in the context of a difficult political dynamic where they are still very clear that their aim is to bring down net migration, which last year was 504,000, which I think is the all-time high net migration figure. Yes, there's some Ukraine, Hong Kong, Afghanistan aspect to that, but not that much. A lot of that comes down to the international student numbers, and Suella Braverman has said as Home Secretary she still wants to get the target, I think, below 100,000, which is a staggering aim. The Conservatives have talked about that for a decade plus and never achieved it, but there's still that aim for sort of downward pressure on the numbers. Allied to that, we've got a significant increase in the number of sponsors, number of businesses who can sponsor the skilled worker visas and other types of visa, because obviously the ending of free movement means that's required if you're to recruit EU labour, which many more businesses in the UK are doing than non-EU labour. So we've got that dynamic in play as well, together with the global mobility increase, a hybrid working, international cross-border working, all on the up, lots of businesses grappling with the issues around that. So quite an interesting, challenging policy dynamic we've got in play at the moment. So how could that play out in the next few months? I think some of the possible areas of focus I've put on the slide here. I think the agricultural sector is an area of focus, and perhaps more so given the shortages in Tesco of your peppers, your tomatoes, all the things that people like. People don't want to eat turnips all year round, which is what some parts of the government seem to be suggesting we might need to be doing. So I think there is going to be a focus on wanting to allow more people to come in on a short-term basis, at least, to fill roles in that sort of sector. So I think watch this space on new schemes or expanded schemes like the agricultural workers scheme over the next few months on that. There could be an increase in salary thresholds for sponsored visas. So you'll know if your business sponsors people for visas that they have to meet a minimum salary threshold. We've obviously had inflation and increase in wages, which I think were a 6.4% increase September to November last year. Arguably, the salary thresholds are trailing behind where salaries are now at, and they've gone up more, I think 7% and a bit in the private sector. So it wouldn't surprise me if over the coming months, the salary thresholds to qualify for visas will increase to reflect that. That may not be a problem for many businesses, but if you are recruiting people and the salary is always a bit on the borderline, that will be something to be looking at and checking and working out, do we have issues there? We could have a review of the shortage occupation list. The Migration Advisory Committee, which advises the government, was commissioned to do a review of the skilled worker route, which was put on hold for a while due to various changes in government policy. But I think that is potentially a way the government's going to look at this. Do we need to have more roles on the shortage occupation list, perhaps across those high skill areas of the economy, certainly in the health sector as well? I think we could see more roles possibly added to that list. If the government is to drive down numbers, it's going to have to be, I think, around some of the non-economic routes and trying to focus on allowing perhaps more people in terms of the economic migration, at least for highly skilled roles. And the use of the shortage occupation list is one way in which that could be done. Don't lose sight in your role as an in-house lawyer on right to work compliance and linked to that sponsor compliance. We've got more sponsors. Yes, Home Office resources have been checked. Have been under challenge recently, but the government and the Home Office has emphasised that compliance by sponsors remains, a key issue. And if you haven't got good things in place, you haven't got good processes, you haven't got good right to work compliance in place, your sponsor processes are not what they should be, there's a risk on an audit, and in theory you should be audited once every sponsor license cycle, that those issues will be identified and you could face difficulties off the back of that. So do think about, if you've not had an audit for a while, do we need to think about an audit? Do we need to make sure our processes are up to date? Do we need to be doing spot checks of sponsored and other employee files? Do we need a friendly M&R lawyer to help us with that, coming in and doing a mock audit? These are all things I think to be thinking about. We could see more nuanced arrangements looking at the trade agreements box on that slide. So the government, I think, has shown an interest in linking immigration requirements, visa routes, possibly to bilateral trade arrangements. There have been some signs around that, around some of the short-term routes linked to, I think, India, possibly China, and also, interestingly, Iceland. As more trade deals are signed, it could well be that we'll be faced with sort of visa exceptions or routes linked to that particular country or nationality, particularly for some of the bigger countries, reflecting, I think, an increased diversification of visa routes in the UK and exceptions, as I say, within those different routes. British citizens travelling to the EU, there are changes on the horizon around that, around electronic travel authorisations. So something to be aware of if you've got British people travelling to the EU regularly, or indeed if you're planning on a nice trip to France or Spain or something in the near future. The plan was to roll this scheme out by the Q3 of this year. But I read last night, again, a fast-moving area, that probably the EU isn't going to get organised to get this in place until 2024. But it will apply to all travellers, and essentially you've got to apply for some sort of authorisation before you can travel to an EU country as a British national. So kind of extra layer of hassle and compliance associated with that you need to build in to your planning. So online applications should be relatively straightforward, a 48 to 72 hour turnaround, a small fee attached to that. You'd have to include your biometric details, travel details, and there are some basic suitability questions. They're saying it'll be a kind of a 15-minute application. That probably means for most people it'll take a couple of hours to do it properly. You never know, but yeah, it's something that's going to be coming in. It's not a visa, but it's a digital approval which authorises the carrier, the airline, to take you to that country. And finally, before some questions, I wanted to touch on some hybrid working issues, and in particular how that impacts on sponsorship issues. I think there is a disconnect at the moment. I'm getting lots of queries on this between, if you like, the immigration rules, the immigration system, how it works for sponsors of visas, and how modern working practices are operating, particularly around identifying and reporting work locations. So you'll know if you sponsor somebody, you have to identify their main work location, put that on the certificate of sponsorship, make sure that you report any changes to that work location. And the system isn't really built that well for people who are moving around a lot, doing work overseas regularly, coming to the UK from time to time. There have been indications the Home Office has got this on their radar. It could be something that will be addressed in more detail in future iterations of the sponsor guidance that will be coming out. Where I think it does merit thought at the moment is making sure if you have got people sponsored on visas, have their work locations changed? Is their work location, their main work location, still the office in the UK? Or are they working principally at home? Should that be reported? Has their role changed in any way in light of their working requirements? Does that need to be reported? Failure to make these change of circumstances reports is a compliance failure. And if it's systematic across the board, then potentially the Home Office may take the view that you don't know what your sponsorship duties are, and are you a business that should really be holding a sponsor license. So review your policies, review your procedures, check on your existing staff, make sure that records are up to date and reporting has been done. There is some talk about, should there be a digital nomad visa for remote workers? I can't really see that coming into play. Frankly, I think it's too difficult in my mind for the government to sort of implement successfully. So I think the focus will be on how can we update the sponsor guidance to give more information to sponsors for this new way of working. I think that will be a key thing on the horizon, probably for later this year. Good, so I think I've talked for probably my allotted 30 minutes. So I'm really keen to try and pick up any questions people may have, or comments, or indeed feedback. I think Rachel's been monitoring the chat feed. So Rachel, I don't know whether we've got anything picking up on what I've said that we can try and pick up.
Yeah, no, we've had a few questions in the Q&A function, one of which goes back, I think, to some of your earlier slides around online checks and whether you still need to see physical BRP.
So the answer to that is no. If you're doing an online check, the prospective employee just needs to give you the share code and you need to go onto the online system and do the check that way. There is no requirement to be seeing and checking the BRP. I mean, if you wanted to ask to see a copy of that and retain a copy of that, there's no particular harm in doing so, but it's not necessary for the check. And I would suspect if the person refuses to provide it and says, no, I'm giving you the details for the online check, you would need to go with that and accept that as a way to proceed.
Okay, great. Another question here around renewing a sponsorship and when you need to request additional COS allocation. Do you need to apply for it for all renewal visa applications at the beginning of the year?
Yeah, that's a very good question. So there are two different kinds of certificate of sponsorship, what they call defined certificates, and then secondly, undefined certificates. Defined certificates must be used for all entry clearance applications, so people who are applying for visas from overseas. And for those, you have to apply to the Home Office on a case-by-case basis. So you fill out some details about the role you're recruiting to, ping it off. The Home Office should, if they're happy, then give you a defined COS for that role within 1 to 2 working days. So you must use defined COSs and apply on a case-by-case basis where the person is applying for entry clearance. What the question is focusing on is the undefined certificates, which are the certificates that you use in all other circumstances, so extensions, change of employment applications, people moving from a sponsor in the UK to you as another sponsor, where you have an annual allocation of undefined certificates on your sponsor management system. The way it works is that typically you have to apply for your annual allocation once every 12 months. And the people who run your sponsor management system should get an alert that that is what they need to do. So what you have to do is thinking about, okay, well, how many extensions have we got coming up this year of existing employees on visas? What's our likely recruitment dynamic this year? How many people might we need coming into the UK, not coming into the UK, to be sponsored for visas whilst they're already in the UK? And framing your requests for numbers based on that. And you have to give pretty good reasons in support as to why you need the particular number that you need. As a very rough rule of thumb, the higher the number that you request, the more specific, I think, the information you're going to have to put as to why you need that number. They're not generally that keen on granting more undefined certificates than you really need. So yes, you do have to apply annually. Very occasionally, the Home Office seems to make a decision to give you an automatic annual allocation, but typically you'd have to apply annually. If you've not done that, you've missed the deadline for doing that, or you need extra ones, you can apply for those during the year. There is a service standard timeline that's standard of 18 weeks for turning that around. Obviously, not particularly useful when you're trying to recruit somebody. But there is a priority service that you can use for that by paying an extra fee, I think, of £200, where you can get the request processed more quickly. I think I'm right in saying within 10 working days. So that's something to look at. If you urgently need that allocation, you've missed a deadline for doing it, or you need extra ones, you can make use of that priority service to do that. If you search for that online, you'll find a priority service form. The way it works is you complete the usual application via the sponsor management system, and you then have to go through this priority service process and pay the extra fee if successful to get the application expedited.
Great, thanks, Alex. That was a good answer. And we've had a question here around typically how long it will take for a company to be registered as a licensed sponsor and how long potentially that company might need to have been established for in order to make the application.
Yeah, that's a good question. So the standard processing time is around 8 weeks. So from when the application is lodged, it would typically be about 8 weeks. It can sometimes be quicker than that. It depends on the sort of business you are, your profile, your risk profile, the sector that you're operating in. If you're in a lower skilled sector, typically it takes a bit longer in my experience than in a high skilled sector like life sciences, technology, or something like that. Again, if you urgently need it, you can potentially pay an extra fee of £500 and get an expedited service, where I think the turnaround time from memory is 10 working days. But it's not guaranteed you can use that service. What will happen is you'll lodge the application, the Home Office will do an initial screen, if you like, and if they're satisfied to offer you the expedited service, you'll get notified of that. And then there's a bit of a bun fight in order to try and get one of the limited number of slots available each day to get it processed on an expedited basis. We do sponsor license applications all of the time. So very often businesses come to us, say, want to register as a sponsor. We can do that process from beginning to end, and also work on getting one of those priority slots. We've got quite a few of those recently for businesses. That's certainly something we can help with to get that through as quickly as possible, if that would be useful.
Great. Okay. Few more questions here. One around global talent visas and the qualifying period for an ILR, which depends on how the person was endorsed in the first place. The question, I think, is with fulfillment of GT, 11.1A, would 2 years on a skilled worker and then 1 year on a GTV meet that 3-year qualification requirement?
I'll fess up and say off the top of my head, I'm not absolutely certain. I can't give you an answer. I think you can definitively rely on, off the top of my head. It's certainly the case that one of the attractions of global talent, the global talent route, is an accelerated path to settlement, which is normally 3 years, 3 years in the UK to get settlement, rather than the usual 5 years in most other routes. Exactly what the combination options are if you spend time on other work visa routes, I'm not certain. I would have to check that, I'm afraid.
The questions keep coming in, I'm afraid, Alex. Following a GP transfer, is it correct that you have 20 days to apply for a sponsorship license, or are there any other further time limits to be aware of in relation to that?
Yes, another good question. So if you are a business and there's been a GP transfer and sponsored staff have transferred to you from another business, so transferred under GP, then yes, you must apply if you want to continue employing those individuals for a sponsor license. And I think you're right in saying that the timescale for doing that is 20 working days from the date of the transfer. So that's something you would need to be getting on with. If you don't do that, then potentially you will not be able to continue to employ those individuals because you won't have done necessary steps to keep sponsoring them.
And then I think final question, what is the annual deadline for applying for an undefined COS allocation?
Well, that will depend on your cycle. So typically they tend to fall sort of April time to April time, but not always. Some businesses will have an allocation period that is different, linked to the timing of their application originally for the license. So what you need to do is go on to your sponsor license on the sponsor management system, go on to the license summary section of that system. So pull up that page. That will tell you towards the bottom of that page what your current allocation of undefined certificates is, the time period it relates to, the number of certificates that you've got left, the number that you've used. And you can see from that, obviously, when you need to be getting your application in. As I say, you should also, the authorising officer on the licence should also get an alert and chaser alerts up until that deadline to make that application, in good time. As I say, it's not the end of the world if you don't do it. You can do it and make use of the priority service potentially, but there's an extra cost associated with that, certainly some administrative hassle in order to get that through. So worth getting onto that and checking that sooner rather than later. I noticed there's one other question in there which says, do we have any introductory training on immigration? To which the answer is yes, we do. I regularly deliver training. So for example, an overview of the points-based immigration system, how it works, sponsor compliance issues, how you manage sponsor compliance issues, common pitfalls. That's something that we do sort of day in, day out. So really happy to have a chat about how we can help with that. I think it's good in getting a good kind of overview, I would say, of the system, the rules, the kind of the key red flags, the major holes you can fall into. So yeah, very happy to have a chat about that offline, if that would be useful at all. I think Rachel disappeared for a moment, but is now.
Apologies about that. My computer decided to give up on me for a second there. But I think that if I'm right, Alex, that concludes the webinar for today. And thank you everyone very much for joining.